Well, good afternoon, everybody. It's been a while, but we finally have the latest motion from Kathleen Zellner, and I'm going to savor every last word of that. As you know, I'm no legal expert, but I am looking forward to having a chat with Rob Belling on the subject of the latest filing from Kathleen Zellner. Some of you will know that Rob Belling he describes himself as the talking head alongside Anjanette Levy when the Stephen Avery trial was first taking place. And he's got some interesting thoughts on that, as well as obviously he's been involved with the Eagle Nations case, Michael Funk. And also, rather bizarrely, was actually one of several defense attorneys for none other than Ken Kratz later on following the sexting scandal. So Rob has a good insight. He is a defense lawyer, but he's a pretty cool guy, plays in a band called Retrial. So I'm looking forward to chat with Rob. I have been keeping in touch with him, updating him on things. And interestingly, as a defense lawyer, he was saying he's not 100% sure about Kathleen Zellner. Hopefully this latest motion will allay such fears. It seems to be very well written, but as I say, I'm no legal expert, but it seems to me, well, let's read through it and see what she's written. Let's share screen first of all, that would help. And let's go for that one up there. So here is the actual document, apparently 100 pages long. But don't worry, a lot of the pages are actually exhibits, and some are repeat exhibits. It's almost as if she's really trying to inculcate to Judge Sukowicz that this really does have to be looked at and taken seriously. I've dotted every I, crossed every T. Let's have a look. Let's come on down. So page 2, table of contents, table of authorities, introduction, statement of the case, procedural history, including third-party suspects, the verdict, post-conviction and direct appeals, the appellate court's July 28th, 2021 decision. So it's been over a year since the appellate courts turned Steve down and this petition for review, and the appellate court reserved Mr. Avery's ability to file a successive 97406 motion on certain claims. Evidence supporting Mr. Avery's third 97406 post-conviction motion, newly discovered evidence, new witness, provides direct connection between Bobby and the Holbach murder. One, the Sawinski report was discovered after Mr. Avery's conviction. Mr. Avery was not negligent in seeking the evidence. The evidence is material to an issue in Steve's case. The applicable law regarding Denny, the Denny requirements are now satisfied. They are that Bobby's motive to commit the murder of Teresa Holbach, Bobby's opportunity to commit the murder of Teresa Holbach, and Bobby's access to items of evidence to frame Steve. Bobby had access to Steve's blood and Bobby's direct link to the murder of Teresa. The evidence is not cumulative. Reasonable doubt as to Mr. Avery's guilt. 2, Brady violation regarding the Sawinski evidence, applicable law regarding Brady, and Mr. Avery is not procedurally barred from raising his Brady claim. A second Brady violation regarding Teresa's RAV4, Mr. Avery is not procedurally barred from raising his Brady claim. In the alternative, Mr. Avery is entitled to a new trial in the interest of justice pursuant to Statute 805.15. An evidentiary hearing is required. And finally, page 45, a conclusion. So not that much to get through, really. Table of points and authorities. So she cites these various cases. Once again, we see there Brady and a whole load of others. There's Denny, of cases that need to be looked at. I was thinking that Wayinski would be there somewhere, but Wojcicki, sorry. Oh, probably. Yeah, there it is. State versus Wojcicki, a very recent one that had our good friend Travis very excited. The basis of that one is you're not allowed to hide, so that the defense has to seek. And various statutes that are being quoted. All very interesting stuff. So notice of motion and third motion for post-conviction relief pursuant to Wisconsin Statutes 97406 and 80515. Please take notice that the petitioner, Stephen Avery, by and through his current post-conviction attorneys, Kathleen T. Zellner and Associates, PC, respectfully moves this court pursuant to Wisconsin Statute 97406 for an order vacating the judgment of his convictions and sentence and ordering a new trial. In the alternative, he asks that this court grant a new trial in the interest of justice pursuant to Wisconsin Statute 80515 or its inherent authority, because the real controversy was not fully tried. In support of his motion, Mr. Avery states as follows. Mr. Avery requests an evidentiary hearing and that he be produced, in other words, be able to attend that hearing, I presume, be produced for that hearing. Introduction. 2 new witnesses have emerged in Steve's case with new and compelling evidence about a murder mystery that has intrigued a worldwide audience. Well, you're certainly not wrong there, Kathleen. The rush to judgment and tunnel vision that led to the arrest, prosecution, and conviction of Mr. Avery is exposed by these new witnesses who provide new and undisputed evidence that directly links Bobby to the murder of Teresa Holbach and the framing of Steve. Furthermore, this new evidence allows for a reconsideration of the real motive of this crime as being a sexual homicide, which was the culmination of an obsession by Bobby with viewing thousands of images of violent, deviant pornography. On October 31st, 2005, the obsessive fantasies of Bobby became a horrible reality when Teresa Holbach was brutally assaulted and murdered by 2 rifle shots to her skull. Her body was mutilated, as were many of the female subjects in the Dassey computer images. Bobby was in possession of the Holbach vehicle, which contained the crucial evidence of this terrible crime. Teresa's blood, key to the car, electronic devices, and the license plate, which of course was concealed in another salvage car, and Steve's carefully deposited blood on the seats and dash, and DNA on the hood latch. By being in possession of the vehicle, Bobby was able to control the direction of the investigation. He planted the vehicle on the Avery property after he deposited Mr. Avery's blood and DNA in it. He had Mr. Holbach's key and electronic devices, which ended up in Steve's bedroom and burn barrel. Bobby did all of this to exculpate himself and to frame his uncle, Mr. Avery. Mr. Steve does not have to prove who committed this terrible crime to receive relief. This is not his intent or purpose. However, he does have a right to prove he did not receive a fair trial. The new evidence, which establishes that Bobby meets all of the Denny criteria to be a third-party suspect, and the evidence of 2 Brady violations demonstrate that Mr. Avery was deprived of a constitutionally guaranteed right to present a complete defense to the charges against him. And here we see some of the state cases quoted: Holmes v. South Carolina, the state v. Pilizzano, and Chambers versus Mississippi. Of course, I find it quite interesting, just coming back to that business of the DNA on the hood latch. I don't think anybody put DNA on the hood latch. I think Kathleen Zellner is quite right when she says that it was simply a switch. But of course, I suspect that with the with this Judge Sukowicz, she doesn't want to muddy the waters with things that they think are as fact, which have been legally declared as fact, proven as fact as far as they're concerned. So I think she's quite happy to go along with whatever whatever vague ideas they have, and simply try and focus on the most important matters. You know what I mean, rather than a lot of other issues. So just happy to go along with the fact that Steve's DNA was found on the hood latch. But of course, we know differently as to how it got there. Anyway, again, interesting statement of the case. One, this case began in early November 2005 with the disappearance of Teresa Holbach, a 25-year-old professional photographer. I mean, as far as most supporters of Steve are concerned, we would say this case goes back to the early 80s when Steve was regularly getting into trouble and culminating in him running Sandy Morris off the road and the sheriff's department deciding that they were going to stitch him up for good. But again, Kathleen Zellner doesn't need to go over all of that kind of stuff, even though it's really very important. There will hopefully be a time later on down the lane, in the future, when the sort of real motives start to appear, although we already know. So Teresa was reported missing on November the 3rd, 2005. Volunteer searchers found Teresa's Toyota RAV4 on the 40-acre site of Avery's Auto Salvage, a salvage yard business where Steve and other family members lived and worked on November 5th, 2005. Again, we know how bizarre it was that the car was found, but she's just going to go along with the fact that the car was found and it was found by these researchers. We're not going to start protesting about how the car was found in this. As I say, we don't want to deviate from the important things here. At least I don't think that's what she would like to do. Now, Teresa had photographed vehicles at this site previously, per Steve's request. According to state witness Bobby, Teresa was last seen walking towards Steve's trailer on October the 31st, 2005. After finding Teresa's RAV4, law enforcement searched the Avery property and, over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit with DNA matching Teresa's, Mr. Avery's and Miss Holbach's blood in the RAV4, the remnants of electronic devices and a camera, the same model as Teresa's, in a burn barrel, Teresa's RAV4 key in Steve's bedroom with Steve's DNA on it, Steve's DNA on the hood latch of the RAV4 deposited, the state later claimed, by Mr. Avery's sweaty hands, and a bullet in Mr. Avery's garage containing Teresa's DNA. Procedural history. Third-party suspects. 3. On July 10th, 2006, before Steve's trial, the trial court entered an order entitled Order Regarding State's Motion Prohibiting Evidence of Third-Party Liability. In other words, a Denny motion. The order specified that if Steve intended to suggest that a third party other than Brendan was responsible for any of the crimes charged, the defendant must notify the court and the state of such intention at least 30 days prior to the start of the trial. The trial court further ordered that the defendant would be subject to the standards relating to the admissibility of any third-party liability evidence pursuant to State versus Denny. 4. In light of the court's order, on January 10th, 2007, Steve filed the defendant's statement on third-party responsibility. There, Steve stated that he did not kill Miss Halbach and that there was at least a reasonable possibility that one or more unknown others present at or near the Avery salvage yard on the afternoon of October 31st, 2005, killed her. Mr. Avery identified several persons as potential alternative perpetrators. Guess who's top of the list? Scott Taddick, Andres Martinez, Robert Fabian, Charles and Earl Avery, and the Dassey brothers. Mr. Avery argued that Denny did not apply to the circumstances in his case, and that as a result, he should not be bound by the three-part test set forth in Denny. He further argued that even if Denny did apply to his case, he should be permitted to introduce evidence at his trial of several alternative perpetrators in this case. However, on January the 30th, 2007, the trial court entered its decision and order on admissibility of third-party liability evidence. The court held that Denny's legitimate tendency test applies to any evidence the defendant wished to present regarding potential third parties who might have been responsible for Teresa's murder. The trial court found that in the absence of motive, it certainly may be more difficult for the defendant to offer evidence which is relevant and material connecting a third party to the crime. The court simply finds nothing in the offer made by the defendant that goes beyond the level of speculation. Although, of course, it's always been a bugbear of many people that the state, Ken Kratz, prosecuted Steve and didn't show any motive whatsoever. And yet, in order for Steve to present alternatives, he had to have that motive. He had to have all of the ducks in a line. And of course, we know that the verdict on March 18th, 2007, Steve was convicted following a jury trial of first-degree intentional homicide, contrary to Wisconsin Statute 940-011A, and felon in possession of a firearm, contrary to Wisconsin Statute 941-292A. And of course, amazingly, the jury found Steve not guilty of mutilation of a corpse. So, post-conviction and direct appeal. On June 29th, 2009, that's taken over 2 years, hasn't it? Prior post-conviction counsel filed a motion for post-conviction relief on Steve's behalf, pursuant to 803.32H, seeking a new trial on the grounds that 1, the trial court improperly excused a deliberating juror, and 2, the trial court improperly excluded evidence of third-party liability. However, on January 25th, 2010, the motion for post-conviction relief was denied by the Honourable, I would say more dishonourable, Patrick L. Willis in a written order. Regarding the issue of Bobby's third-party liability, Judge Willis found the only evidence offered by the defendant to show motive on the part of Bobby Dassey consisted of evidence allegedly supporting a motive to frame Stephen Avery. No evidence is offered to suggest Bobby Dassey had a motive to murder Teresa Halbach, Judge Willis concluded. The evidence offered against Bobby Dassey probably did meet the opportunity and direct connection to the crime requirements of the legitimate tendency test because of his presence on the property and the time Teresa was there. However, without any showing of motive, third-party evidence against Bobby Dassey is precluded under Denny. So this motive thing, which was not an issue in Steve's case at all, state didn't need a motive. But if Steve wants to suggest Bobby, he has to provide a motive. And therefore, on December the 14th, 2011, Even the Wisconsin Supreme Court denied Steve's petition for review pursuant to 80810. And so then, wow, again, another 2 years have passed. On February the 14th, 2013, Steve filed his first and only pro se collateral post-conviction motion pursuant to Wisconsin Statute 97406. The motion was denied by the dishonorable Judge Angela Superwich on November the 23rd, 2015. Wow, that is less than a month before Making a Murderer came out. On October the 11th, 2019, current post-conviction counsel appealed the circuit court's denial of Mr. Avery's second post-conviction motion and all of its supplements. He filed motions to stay and remand concerning 2 additional claims. At the appellate court's direction, Mr. Avery raised his claims in his motions to the circuit court as supplemental post-conviction motions. The circuit court denied his motions to supplement. On April 12, 2021, Mr. Avery filed a motion to stay and remand, and the appellate court denied. The appellate court's July 28, 2021 decision on 28th of July, 2021, over a year ago, the appellate court issued a per curiam opinion upholding the circuit court's summary denial of Mr. Avery's claims raised in his 97406 post-conviction motion and 2 supplemental motions, holding Steve's 97406 motions are insufficient on their face to entitle him to a hearing. I always found that quite odd, because I always thought that Judge Riley was quite much in favor. He was the one that was handling it, I believe, up until this the sort of 3 judges got together to deny. So, you know, I can't help wondering if Paul Riley is a bit on Steve's side, but the other 2, was it a Davis fellow, and there was another female judge who had looked at Steve's case before. But yeah, I can't help thinking that it although obviously it was denied and probably on a 2-to-1. I'm speculating there, but probably I'm suggesting that that, you know, probably they. If that did happen, I would imagine the arguments that the judges themselves would have had. And I couldn't help reading through this and thinking, yeah, I get a sense that the appellate court, the appeals court, the 3 judges, no Mark Gundrum, he recused himself, that maybe they were showing, you know, in effect, Kathleen Zellner, well, if you can do this and if you can do that, then we'll look at it. Again, just a sort of observation from no legal point of view, but anyway, let's carry on reading through and see what happens. Okay, on November 17th, the Wisconsin Supreme Court denied Steve's petition for review. Surprise, surprise. The appellate court reserved Mr. Avery's ability to file a successive 97406 motion on certain claims. On April 12th, 2021, during the pendency, while we were waiting, of Mr. Avery's appeal, Mr. Avery filed a motion with the appellate court to stay his appeal and remand for evaluation of a new claim. The appellate court acknowledged this claim, stating the following. On November 9th, 2020, we notified the parties that this case has been submitted to the court for decision on briefs. On April 12th, 2021, Steve filed another motion with this court to stay his appeal and remand for evaluation of a new claim. This claim concerns an alleged Brady violation, the factual basis for which Steve obtained on April 11th, 2021. Specifically, the claim is based on the affidavit of Thomas Sawinski, a Manitowoc motor route driver, who attests that days after Teresa's death, while on his paper round, In the early morning hours, he spotted a shirtless Bobby Dassey and an unidentified older man pushing Teresa's vehicle down Avery Road towards the junkyard. Mr. Sawinski further attested that after he delivered the paper, Bobby Dassey attempted to block his exit, causing him to swerve and drive into a shallow ditch. Mr. Sawinski claimed to have called the Manitrock Sheriff's Office later that day to report what he had seen, but was told they, quote, already know who did it. He also claims to have attempted to contact Steve's trial attorneys after season 1 of Making a Murder, but never heard back from them. So further, in its July 28, 2021 opinion, the appellate court advised, when Steve filed this motion, we had already twice stayed his appeal, each time because he asserted that the new claims related to those previously litigated, and that it would be most expeditious to resolve them as part of the instant appeal. By the time Steve filed this new motion, however, we had already evaluated the legal and factual basis for claims already raised. We therefore were and are in the position to conclude that this newly raised Brady claim bears little or no relation to those claims already before us. This is instead a distinct issue that the circuit court should resolve on a standalone basis through a new motion. So in other words, I get the impression that they'd already sort of made their decision on it and they wanted to give that opinion. Fair enough. Okay. And so hence we're here with our third motion. Steve's latest motion arrived while our decision of his appeal was forthcoming. It would be an inefficient use of court resources to now and once again delay this appeal's resolution. Oh dear, you know, an innocent man causing you to miss your odd round of golf. Dear, oh dear. We appreciate that Steve likely wishes us to consider this new Brady claim in the context of claims previously raised, but we must weigh that implicit consideration against those discussed above. Simply put, Steve's appeal cannot continue indefinitely. Accordingly, this decision operates as an order denying Steve's April 12, 2021 motion to stay and remand. If Steve wishes to raise this claim, he must file a new Wisconsin statute motion with the circuit court. Number 2, Mr. Avery's current post-conviction counsel has investigated the matter further to learn that Mr. Sawinski did not contact Steve's trial attorneys as he originally believed and stated in his original affidavit, but rather that he emailed the Innocence Project in 2016 after watching Making a Murderer, season 1. His email was never passed along to any of Steve's attorneys. I find that rather odd, unless it's just gotten mixed in the lost somewhere. Mr. Sawinski's first attempt to contact Mr. Avery's current post-conviction attorneys was in December of 2020, after Mr. Avery filed his second post-conviction motion in 2017. Further, Mr. Sawinski's memory was refreshed with a recorded dispatch that was recently discovered, in that he made the call to the Manitrock Sheriff's Office on November 6, 2005. And yet we were told explicitly that that recording would not exist. Wow. The appellate court reserved Steve's ability to file a successive 97406 motion on the claim in his most recent filing concerning the new witness who came forth on April 11th, 2021. The appellate court instructed the following. As discussed below, we are not addressing Steve's most recent filing to this court. See our discussion of motion, which seeks to directly connect Dassey to Holbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin Statute 97406 motion. That motion would need to survive both the Escalona-Naranjo scrutiny and be found to have merit, well, in which case the evidence presented might supply the missing direct connection. In that event, the VLE-CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such 9746 motion, as all such issues would be for the circuit court to decide in the first instance. 17. Regarding certain claims Steve raised in his motion to reconsider the circuit court's October 3rd, 2017 order denying his second post-conviction motion and its two supplements, the appellate court found that neither we nor the circuit court have squarely considered whether these claims are procedurally barred under Escalona-Naranjo or whether Steve pled sufficient materials entitling him to a hearing. Such consideration would have to come on a separately filed 97406 motion, and we express no opinion as to whether such claims would be barred in the event such a motion is filed. Thus, the new material that Mr. Avery raised in his motion to reconsider and its supplements was never ruled upon by the circuit court. Next, evidence supporting Mr. Avery's third post-conviction motion. Newly discovered evidence, new witness provides direct connection between Bobby and the Holbach murder and planting evidence to frame Mr. Avery. See, we're up to page 14. We're not doing too badly. We get a couple more. So I want to read through this a few times just to really get a good idea. I've then got to get in touch with Rob and say, you know, these are the bits that I've come across. What do you think? And then we can have a bit chat about it. Maybe even we can get the Hod and Stacey to join us if times can be sorted out. Never know. Anyway, let's look at paragraph 18. Mr. Avery's new witness, Thomas Sawinski, contacted Kathleen Zellner in December of 2020. Steve had already filed his appeal on October the 11th, 2019. Mr. Sawinski stated that he had witnessed Bobby and one other individual, a bearded man, pushing Teresa's RAV4 onto the Avery salvage yard in the early morning hours of November the 5th, 2005. Mr. Sawinski claimed that he had reported this information to the Manitowoc Sheriff's Office. On April the 11th, 2021, Mr. Sawinski provided an affidavit to Steve's current post-conviction counsel stating the following. Thomas was a motor route driver. Also, I'll do the American. Thomas was a motor route driver for Gannett newspapers. I think I'll give up the accent. Mr. Sawinski was a motor route driver for Gannett newspapers Incorporated and delivered papers to the Avery salvage yard in the early morning hours of November the 5th of 2005. Prior to delivering the newspapers to the Avery salvage yard, he turned onto the Avery property and witnessed two individuals, a shirtless Bobby Dassey and an unidentified older male, suspiciously pushing a dark blue RAV4 down Avery Road towards the junkyard. The RAV4 did not have its lights on. Mr. Sawinski drove past the two men and delivered newspapers to the Avery mailbox. And then he turned around and drove back towards the exit. When he reached The RAV4 still there. Bobby Dassey attempted to step in front of his car to block him from leaving the property. Mr. Sawinski came within 5 feet of Bobby Dassey, and his headlights were on Bobby during this entire time. Then Sawinski swerved into a shallow ditch to escape Bobby and exit the property. Thomas states in his affidavit that he called out, "Paperboy, gotta go," because he was afraid for his safety. He further stated that Bobby Dassey looked him in the eye and did not appear happy to see Thomas there. After Mr. Sawinski learned that Teresa Halbach's car was found later in the day, on November the 5th, 2005, he realized the significance of what he had observed and immediately contacted the Manitrock Sheriff's Office. See Exhibit 1 to Mr. Avery's motion for remand and stay of appeal, Mr. Sawinski's original affidavit. Now, the following day, April 12, 2021, Mr. Avery filed a motion for remand and stay of appeal to the appellate court containing Mr. Sawinski's original affidavit. Throughout this motion, the information Sawinski provided will be referred to as the Sawinski evidence, which is contained in 2 affidavits cited throughout this motion as Exhibit F and Exhibit I. F and Exhibit 1, I presume. Okay, to Mr. Avery's motion for remand and stay of appeal. Yeah, so it looks like an F and a 1, but we might find out later on. The Sawinski evidence provided by Thomas to Mr. Avery's current post-conviction counsel is newly discovered evidence, which provides the missing direct connection between Bobby and Miss Halbach's murder, making him a Denny suspect. As I say, she's doing her best to really spell it out. This is what you've asked me to do. This is what I'm doing. The discovery of new evidence may constitute a sufficient reason for a second or subsequent post-conviction proceeding under Wisconsin Statute 97406. To prevail, however, the movement must carry the burden of proving that the evidence at issue is newly discovered. In most cases, to obtain relief based on newly discovered evidence, a convicted person must establish by clear and convincing evidence that 1, the evidence was discovered after conviction, 2, the defendant was not negligent in seeking evidence, and 3, the evidence is material to an issue in the case, and 4, the evidence is not merely cumulative. If the person satisfies those 4 requirements, then the circuit court must determine whether a reasonable probability exists that a different result would be reached in a new trial. The Sawinski evidence was discovered after Steve's conviction. So, 22. Mr. Avery did not have the Sawinski evidence before Mr. Sawinski came forward to Mr. Avery's current post-conviction counsel in April of 2021. Mr. Sawinski attempted to contact the Innocence Project and not Steve's trial defense counsel via email in 2016 regarding the evidence he had, to no avail, and had not previously provided it to Mr. Avery's counsel. Rather, the Sawinski evidence was reported to the Manitrock Sheriff's Office by Mr. Sawinski, but the evidence was suppressed from Steve by the prosecution. As I say, this is newly discovered evidence, but also he has to prove that they weren't negligent in looking for it. Mr. Avery was not negligent in seeking this evidence or anything similar to it. 23. Neither Mr. Avery nor his counsel were on notice that Mr. Sawinski had any knowledge about Bobby's actions on November the 5th, 2005. It quotes a case here, Williams versus Taylor, finding that Williams had not failed to use diligence in pursuit of a juror misconduct claim where the trial record contains no evidence which would have put a reasonable attorney on notice that juror Stinnett's non-response was a deliberate omission of material information. Anyway, the evidence is material to an issue in Steve's case. The Sawinski evidence is material to several issues in Steve's case. Most importantly, it is material for establishing Steve's defense. That is, that a third party committed the crime against Ms. Halbach. It is material for establishing the direct link to Bobby as a third party Denny suspect, and to opening the door to reconsidering the Veely CD as establishing a sexual motive for the murder. Additionally, the Sawinski evidence is material to the evidence in the RAV4 being planted by Bobby, including Steve's blood and DNA. The RAV4 also contained the Halbach vehicle key and Miss Halbach's electronic devices, which were discovered in Steve's bedroom and burn barrel, respectively. Further, the Sawinski evidence is material to impeach Bobby's trial testimony that Miss Halbach never left the Avery property and that she was last seen walking towards Mr. Avery's trailer. Bobby was the state's primary witness against Mr. Avery. During his opening statement, the sweaty prize explicitly informed the jury of the significance of Bobby's putative observations on the date of Teresa's disappearance. You are going to hear that Bobby Dassey was the last person, the last citizen that will have seen Teresa Halbach alive. Bobby's testimony was the most determinative of Mr. Avery's guilt because the state used it to establish that Teresa never left the Avery property alive. Bobby was one of only two witnesses whose testimony the jury requested for review during deliberations. At trial, Bobby testified that he observed Teresa's light green or teal-coloured SUV pull up in his driveway at 2:30 on October the 31st, 2005. Bobby then observed Teresa exit her vehicle and start taking pictures of his mum's maroon van right in front of his trailer. Bobby testified that he then observed Teresa walking towards the door of Steve's trailer. The following exchange occurred between Prosecutor Kratz and Bobby. Question: after seeing this woman walking towards your Uncle Stephen's, did you ever see this woman again? Answer: no. Applicable law regarding Denny. 28. When a defendant seeks to present evidence that a third party committed the crime for which the defendant is being tried, the defendant must show a legitimate tendency that the third party committed the crime. In other words, that the third party had motive, opportunity, and a direct connection to the crime. State versus Denny. That's why it's called Denny, isn't it? To support the introduction of third-party perpetrator evidence, there must be a legitimate tendency that the third person could have committed the crime. The defendant need not establish the guilt of the third party to the level that would be necessary to sustain a conviction. However, evidence that simply affords a possible ground of suspicion against another person should not be admissible. The legitimate tendency test asks whether the proffered evidence is so remote in time, place, or circumstances that a direct connection cannot be made between the third person and the crime. But the Denny requirements are now satisfied. A. Bobby's motive to commit the murder of Teresa Halbach. Under the motive prong, the court must question whether the alleged third-party perpetrator had a plausible reason to commit the crime. State versus Wilson, State versus Griffin. A defendant's motive to commit a homicide is widely considered to be relevant State versus Wilson, the admissibility of evidence of a third party's motive to commit the crime charged against the defendant is similar to what it would be if that third party were on trial himself. Now, other acts evidence may be admitted when offered for the other purposes, such as proof of motive, opportunity, intent, preparation plan, knowledge, identity, or absence of mistake or accident. Now, law enforcement considered pornography as evidence of motive in Teresa's murder. The clear working theory of the investigations was that the murder of Teresa Halbach was motivated by a sexual assault. Pursuant to that theory, the Dassey computer was seized by law enforcement on April 12, 2006. Evidence of Bobby's motive to commit Miss Halbach's murder is contained on the hard drive of the Dassey computer, namely the material contained on the VLE-CD. The appeal court acknowledged this evidence could be relevant for establishing the motive element of the Denny test if the new evidence directly connected Bobby was raised. Specifically, the appellate court stated, the evidence, that is Thomas Sunsley's evidence, presented might supply the missing direct connection. In that event, the VLE-CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. Detective Veely's forensic examination of the Dassey computer searched for specific words the user had searched. Detective Veely selected the specific words and conducted a search for those words. There were 2,632 search results for the following words: blood, body, bondage, bullet, cement, DNA, fire, gas, gun, handcuff, journal, MySpace, news, RAV, stab, boat, tires. These selected words establish a direct link between the specific evidentiary claims related to the Halbach murder and the searches performed on the Dassey computer. The VLE-CD contains the state's recovered pornography images relevant and material to the Halbach murder. The VLE-CD refined the 14,099 images on the seven DVDs that Trial Defense Counsel received in discovery and recovered 1,625 violent pornographic images which had been deleted. The recovered porn depicted violent images of the torture and mutilation of young females. Brad Dassey, number 37, Brad Dassey, Barb's stepson and half-brother of Brian, Bobby, Blaine, and Brendan, avers that he had a conversation with Barb in which she indicated that she had hired someone to remove evidence from the Dassey computer. The authorities interviewed Brad after he reported this information, but he was not called as a witness by either side to testify at Mr. Avery or Brendan's trials. Affidavit of Brad Dassey. This is corroborated by the law enforcement report, which states that on June the 6th, 2006, Special Agent Fassbender and Investigator Wiegert, better known as Bert and Ernie, interviewed Brad, who provided this information about the Dassey computer deletions. Thomas Fassbender DCI report is attached and incorporated therein as Group Exhibit A1. The new forensic examination of the Dassey computer corroborates the affidavit of Brad. Mr. Hunt, in his computer examination, detected 8 periods in 2005, close to the date of the murder, for which files were missing and presumably deleted from the Dassey computer. August 23rd to the 26th, August 28th to September the 11th, September 14th to 15th, September 24th to October 22nd, October 23rd to 24th, October 26th to November the 2nd, November the 3rd to the 13th, and November 15th to December the 3rd. Supplemental affidavit of Gary Hunt. In reviewing images contained on the VLE disc, Special Agent Thomas Fassbender made the following observations. 1. Photographs of both Teresa Holbach and Stephen Avery with an apparent date of April the 18th, 2006. There were numerous images of nudity, both male and female, to include pornography. The pornography included both heterosexual, homosexual, and bestiality. There were images depicting bondage, as well as possible torture and pain. There were also text images with the name Emily. There were images depicting potential young females, to include an infant defecating. There were images of injuries to humans, to include a decapitated head, a badly injured and bloody body, a bloody head injury, and a mutilated body. And the disc received from Detective Veely, as well as the hard copy pages of instant message conversations, were maintained in Fassbender's possession. Thomas Fassbender DCI report is attached and incorporated herein as A2. There is sufficient evidence that it was only Bobby who had access to the Dassey computer during the day on weekends between approximately 7 a.m. to 3:30 p.m. Barb's work schedule was from 6 until 4:30 every day, Monday through Thursday of every week. Brendan and Blaine would get picked up by the school bus at Avery Road between 7:08 and 7:13 and dropped off at the same place between 3:30 and 4 o'clock. Therefore, Barb, Blaine, and Brendan, the three other individuals living at the Dassey residence, are excluded from even having access to the Dassey computer at the times most of the violent searches occurred. Moreover, 128 searches for the most violent porn images primarily occurred on weekdays when only Bobby was in the Dassey residence. It is undisputed that Mr. Avery never accessed the Dassey computer. He did not have the password for the Dassey computer, nor did he possess a key to the residence, which was locked when no one was home. The only time Steve ever entered the Dassey residence was when one of the Dassey family members was home. Steve worked at the auto salvage yard during the weekdays from 8 till 5. Moreover, Steve would be eliminated from all but 15 of the 128 searches, that's 11.7%, for the most violent porn images at issue simply by having been arrested on November the 9th, 2008. Brendan would be eliminated from all but 26 of the 128, 20% of the searches for the most violent porn images at issue simply by having been arrested on March 1st, 2006. Bobby testified that on October 31st, 2005, he was the only person home between 6:30 and when he claims he left to go hunting at 2:45. Therefore, it is undisputed that Bobby was the only person home on October 31st when searches were made on the Dassey computer at 7 o'clock, 9:33, 10:09, 1:08, and 1:51, prior to Miss Holbach's arrival at the salvage yard. Affidavit of Gary Hunt. The timings of these internet searches on October 31st directly contradicts Bobby's trial testimony that on that day he was asleep from 6:30 to 2:30. On November 17th, 2017, in an interview of Bobby by state investigators, Bobby claimed that the Dassey computer was located on a desk in the living room at the time. When Bobby was asked if the Dassey computer was ever located in his bedroom, he stated it was not. Bobby's statement is directly contradicted by the crime scene footage taken by Bill Tyson on November the 12th, 2005, which shows the Dassey computer was located in Bobby's bedroom. Bobby's statements are further contradicted by his brother Blaine, who stated in his affidavit to current post-conviction counsel on June 25th, 2018, that the Dassey computer was located in Bobby's room and Bobby was the primary user of it. Wisconsin Statute 9044-2A provides that evidence of other crimes and or wrongs and or acts when offered as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident is admissible. The depicted acts in the violent pornography Bobby was viewing are sufficiently similar to the violent murder of Miss Holbach. The evidence of Bobby's searches for violent pornographic images is not so remote in time as to be inadmissible, but rather so close in time to Miss Holbach's murder that the searches are direct evidence of Bobby's motive to kill Miss Holbach. The 1,625 previously deleted but recovered images of violent pornography could have established motive for trial defense counsel's Denny motion. The court in Dressler versus McCorkry held that the acts admitted pursuant to 9044-042 were the defendant's possession of the pornographic videotapes and pictures. Those images depicted intentional violence were admitted as evidence of the defendant's motive, intent, and plan to murder the victim. The defendant in Dressler argued that the videotapes and pictures were irrelevant and constituted inadmissible propensity evidence, but the Seventh Circuit Court, for once got it right, I presume, disagreed, stating the fact that the defendant maintained a collection of videos and pictures depicting intentional violence is probative of the state's claim that he had an obsession with that subject. A person obsessed with violence is more likely to commit murder, and therefore the videos and photographs are relevant. The Dressler court held that although evidence of the general character of a defendant is inadmissible to prove he acted in conformity therewith, the above exception from 904042 was deemed to apply. And Dressler is persuasive authority that the same result should occur here. Ms. Holbach was killed in a violent manner. Maintaining the violent porn images is probative to establish that Bobby had an obsession with violence and therefore was more likely to commit murder. The violent porn images are relevant to Bobby's motive and would have resulted in trial defense counsel being able to establish his motive for Teresa's murder to meet the Denny standards. As Mr. Avery's sexual homicide expert, Anne Burgess, opines in her affidavit submitted previously to this court, there is a well-established causal connection between pornography consumption and violent behaviors. In Mr. Avery's motion to reconsider this court's prior decision, former FBI agent and police procedure expert Greg McCrary, Mr. McCrary, submitted an affidavit wherein he described his opinion that the searches for violent underage and child pornography, combined with the images of and searches for dead body, reflects a comorbidity of sexual paraphilias. It is the opinion of Mr. McCrary that Bobby Dassey was becoming obsessively deviant in his viewing of violent pornography in the weeks before Teresa's murder. Affidavit of Greg McCrary. Wow, we've done up to the top of page 24, which is quite good going. I think we'll leave it there. Let's digest. Let me first of all digest what's being put, what's here in this motion. And I say I do believe that to coin a phrase of Sweaty, it's the specificity that the courts want. That seems to be what Kathleen Zellner is saying. Well, if this is what you want, this is what you're going to get, and has has sort of laboured one or two points quite a bit, I would say. But we haven't even got to the best bit about this whole motion, which is, we've talked, haven't we? Let's just close that off for a minute. We've talked about this case for so long, and Mike Osmondson has always been shall we say, a suspicious character. So let's look forward to the next part, or maybe part again, when we actually get to hear from Mr. Osmondson and his bizarre comment. And also it would appear that the telephone call that Thomas Lewinsky made to Manitowoc County Sheriff's Department has now been found. But remarkably, it seems as if, and Jerry Buting has tweeted to this effect, that it came about because they hired a new clerk of the the sort of that handled all the FOIA requests and stuff, and she sort of inadvertently handed over exactly what Kathleen Zellner was looking for, which had previously been denied to her. What a surprise. Anyway, as I say, it does seem to me as if Kathleen Zellner is avoiding arguing about anything other than this is the facts, and this is the reason why you need to have an evidentiary hearing, and really doing it the way that the appellate court has asked her to do. So although they denied, there does seem to be this sort of light at the end of the tunnel, certainly from my point of view anyway, and I'm sure a lot of other people out there will feel the same. Okay, so as I say, we're at the top of page 25. We've got a fair bit more to go yet, but that'll do fine for today, and we'll catch you all again soon. Bye for now.